deep dive. You've sent us a fascinating stack of sources, and today we're taking a deep dive into something really vital, often quite complex and always evolving: India's human rights protections. Look, it's a topic that can feel overwhelming, right? So we're here to try and cut through some of that complexity. Our focus today is squarely on India's, well, its multi-layered system, the institutions, the legal frameworks, all designed to safeguard these fundamental rights.
Exactly. And our mission really is to give you a shortcut, a way to understand the key agencies involved, the kinds of violations they typically deal with, and perhaps the most surprising part, the sort of groundbreaking ways India's own courts are actually expanding what those rights mean for every single citizen. We'll pull out the key insights from all the material you sent.
Okay, so get ready for some genuinely surprising points, I think, and hopefully a much clearer picture of who protects whom and how in one of the world's biggest democracies. Right, let's kick things off with maybe a fundamental question. It often has nuances we don't immediately think about. Who actually perpetrates human rights violations? And crucially, who are the victims? It's not always as clear-cut as it might seem.
That's a really crucial starting point. Our sources point to two main categories of perpetrators. First, you have what are called state actors. These are people like government officials, law enforcement, police, paramilitary forces, even members of the armed forces who misuse the power they're given.
Okay, so official bodies or people acting officially?
Yes, but it's not just the state. There are also non-state actors. Now, this can be private individuals, it could be corporations, or maybe extremist groups operating outside government control. But here's what's really key, I think. Even if the act itself is by a non-state actor, the sources emphasize that the state still bears the ultimate responsibility.
Ah, so the buck stops with the government, basically, even if it wasn't their direct action. That's a pretty powerful idea. Why is that so important, that the state has ultimate responsibility?
Well, it's fundamental, really, to the whole concept of human rights. The state is seen as the primary duty bearer. Its job isn't just to avoid violating rights itself. It also has to actively protect its citizens from violations by others. By having the right laws, making sure they're enforced, providing ways for people to seek justice. If the state fails in that protective duty, even if the violator was a private company, the state can still be held accountable. It's about ensuring a safe environment for everyone.
I see. And what about the victims? Who typically bears the brunt?
Historically and, well, tragically, it's often the most vulnerable groups in society.
Which groups are we talking about here specifically?
We're talking about people from marginalized sections, so women, children, scheduled castes, scheduled tribes, various minorities, people with disabilities, migrant workers. Often these communities face systemic disadvantages that just make them more susceptible. But, and this is really important to clarify, any person can become a victim. Think about illegal detention or torture or having your free speech shut down. It cuts across all walks of life, so the protection needs to be broad.
Okay, that makes sense. So let's turn to the big player here. The National Human Rights Commission, the NHRC. What exactly is this body? What's its core mission?
Right, the NHRC. It's India's apex human rights body. It's what's called a statutory body, meaning it was set up by an act of parliament, the Protection of Human Rights Act, back in 1993. Its main job, essentially, is threefold: to protect rights, to promote awareness of rights, and to inquire into violations across the country. Think of it as the lead watchdog.
A watchdog.
Yeah.
And who actually sits on this commission? Who leads it?
It has a very specific, high-level composition designed to give it, well, weight and expertise. There's a chairperson who has to be a retired Chief Justice of India, the top judge. Then you have 4 other members. One needs to be a retired Supreme Court judge, another a retired Chief Justice of a high court, and then 2 members who have proven knowledge or practical experience in human rights work.
So a mix of top judicial minds and practical experts.
Exactly. That specific mix is meant to give it both legal authority and real-world credibility. Crucial for its effectiveness,
Okay, so with that kind of composition, what can the NHRC actually do when it finds a violation? What are its teeth, so to speak?
Well, it definitely has broad powers to investigate. It can look into complaints either suo motu, that means on its own initiative, which is powerful.
So they don't need someone to file a complaint first.
Correct. They can just see something happening and decide to investigate. Or they can act based on a petition someone files. And importantly, it has the powers of a civil court, so it can summon witnesses, demand documents, get public records. It also makes visits to jails and detention centers to check on conditions and make recommendations. Plus, it reviews existing laws and safeguards, suggests improvements, and works on promoting human rights literacy. It's quite comprehensive on the investigation and advocacy front.
Okay, but here's where it gets really interesting and maybe a bit controversial sometimes. Despite all those powers, the NHRC does have some significant limitations, doesn't it?
Absolutely. And understanding these limitations is key. The big one is that its powers are largely recommendatory.
Recommendatory, meaning.
Yeah. Meaning it can't directly punish anyone or issue binding judgments like a court can. It can only recommend to the relevant government authority that, say, compensation should be paid or that someone should be prosecuted. Its real strength isn't in direct enforcement, but more in its ability to shine a light, generate public pressure, use its moral authority, and make informed recommendations that push governments to act.
So it's more about influence and advocacy.
Precisely. It's built on that rather than direct orders. And another key point our sources mention is its jurisdiction over violations by the armed forces is limited. There are special procedures for those cases.
That's a really crucial distinction. Okay, so if the main national body works mostly through recommendations, where do people go for more, let's say, immediate or binding justice? Or for issues closer to home? This is where the layers come in, I guess.
Exactly right. The system is designed to be multi-layered. Just like the NHRC at the national level, state governments can set up state human rights commissions, or SHRCs, under that same 1993 Act. They pretty much mirror the NHRC's functions just at the state level. Their jurisdiction covers violations related to subjects on the state list and concurrent list of the Constitution.
Meaning things the state government has power over.
Yes, areas where states have primary or shared authority. It ensures local issues get local attention, hopefully faster. And each SHRC is also headed by a retired Chief Justice of a high court. And then, for even quicker justice, the Act also allows for setting up human rights courts.
Human rights courts in regular districts.
Yes, established in specific districts with the okay of the High Court's Chief Justice, specifically for the speedy trial of offenses related to human rights violations. And to make them work effectively, state governments appoint a special public prosecutor just for these courts. It's fascinating because it creates these dedicated channels aimed at bypassing potential delays in the normal system.
Right, a focused pathway. Okay, so we have the NHRC, the SHRCs providing this broad framework. But you also mentioned India has specific commissions for vulnerable groups. Why that extra layer? Why not just rely on the main commissions?
That's a really good question. It speaks to, I think, a deeper commitment to tailored protection. While the general framework is vital, the specific issues faced by, say, women experiencing violence are very different from the rights of a child needing education, right? These dedicated bodies bring specialized knowledge, they can design targeted interventions, and they understand the specific vulnerabilities in a way a broader commission might struggle to address with the same focus.
Makes sense. So who are these specialized commissions?
Well, there are several key ones. You have the National Commission for Women, NCW, which focuses specifically on safeguarding women's rights and legal entitlements, tackling everything from domestic violence to workplace issues. Then there's the National Commission for Minorities, NCM, protecting the interests of notified minority groups and ensuring their development isn't overlooked. For historically marginalized communities, you have the National Commission for Scheduled Castes, NCSC, and the National Commission for Scheduled Tribes, NCST. Both monitor constitutional safeguards for SCs and STs, fighting discrimination and exploitation, and very importantly, the National Commission for Protection of Child Rights, NCPCR. Its job is to make sure all laws, policies, programs, everything, aligns with the best interests of children.
So it's really not a one-size-fits-all approach.
Yeah.
Recognizing those distinct needs seems crucial for a truly comprehensive system.
Absolutely.
Okay, so we covered the institutions, the backbone. But what happens when the existing laws just aren't enough? Or when new challenges pop up that maybe nobody foresaw decades ago? This seems to be where India's judiciary has really stepped up, hasn't it?
Oh, absolutely. This is where the human rights landscape in India gets incredibly dynamic. It really shows a living constitution in action. The Indian judiciary, through what's often called judicial activism, has dramatically expanded the scope of human rights. They've done this particularly by creatively interpreting the fundamental right to life and liberty, which is Article 21 of the Constitution. It's not just about enforcing the rights already written down. They've actively shaped and even created new protections to meet modern needs.
Created new rights, like what?
Well, for instance, the Supreme Court has repeatedly ruled that the right to a clean environment is part of the right to life under Article 21.
How so?
The reasoning is simple. You can't live a dignified life if your air is unbreathable or your water is polluted. So the courts have declared access to a clean environment a fundamental right. Then there's the massive right to privacy. Remember the Justice K.S. Puddaswamy case in 2017? The Supreme Court declared privacy a fundamental right.
Right, that was huge, especially with technology and data.
Exactly. It was critical for individual autonomy in the digital age. It raised big questions about protecting personal data from both the state and, say, big tech companies. And it doesn't stop there. The courts have also interpreted crucial socioeconomic rights, like the right to food, right to health, and right to shelter, as being integral to the right to life. This makes the state more accountable for providing these basic necessities.
So the courts are essentially saying life in Article 21 means more than just breathing. It means living with dignity, with basic needs met.
Precisely. It's a much broader, more humane interpretation. They're ensuring the Constitution stays relevant to people's actual lives and challenges.
It sounds like the Constitution isn't just a static rulebook, but something that grows with society. Is that the core idea behind this judicial activism?
Yes, that's a perfect way to put it. It's very much a living constitution approach. The courts are interpreting these foundational principles in light of today's realities, ensuring human rights aren't just historical artifacts, but living protections.
Now, beyond just recognizing completely new rights like privacy or environment, there's also this other interesting shift you mentioned, how the courts are interpreting different parts of the Constitution together. Traditionally, some parts were seen as just guidelines, right? Not strictly enforceable.
That's correct. For a long time, the Directive Principles of State Policy, or DPSPs there in Part 4 of the Constitution, were considered non-justiciable.
Meaning you couldn't sue the government if they didn't follow them.
Exactly. They were seen as aspirational goals, guiding principles for the state on how to govern well, but not legally enforceable rights. Similarly, the fundamental duties for citizens in Part IVA were viewed as more like moral obligations. Important, maybe, but not something you could take to court.
Okay, so that was the old view. What's changing?
Well, what we're seeing now is a really progressive approach from the judiciary. Courts are increasingly using these DPSPs and fundamental duties to actually inform their interpretation and enforcement of the core fundamental rights in Part 3. It's like they're weaving these different strands of the Constitution together. They're saying, look, these directive principles show the aim of the Constitution, and these fundamental duties show citizen responsibilities, and we can use them to understand what the fundamental rights mean in practice. It creates a more unified, holistic reading of the Constitution.
Can you give us a concrete example? How does using a non-enforceable principle help enforce a real right?
Absolutely. The classic example is the right to education. Initially, providing education was just a directive principle, Article 45, an aim for the state. But through judicial interpretation, the court started arguing that the right to life under Article 21 would be meaningless without education. This judicial push eventually led to the 86th Constitutional Amendment in 2002, which formally made education a fundamental right under Article 21A.
Wow. So the courts use the aspiration to define the right.
In essence, yes. They linked the DPSP to the fundamental right to life, giving it teeth. Another great example is the right to a clean environment. Again, we saw it emerge from Article 21, but the courts have also linked it strongly to the fundamental duty of citizens under Article 51AG, which says citizens have a duty to protect and improve the natural environment.
Ah, so it connects the state's responsibility under Article 21 with the citizen's duty under 51A.
Exactly. What's fascinating here is this approach creates a kind of dual responsibility. The state has to provide and protect the environment as part of the right to life, and citizens have a corresponding duty to help protect it. It moves beyond just demanding rights from the state towards a more participatory model.
That's a really significant shift. It feels like it moves beyond just legal rights into a broader idea of, well, a just society, incorporating socioeconomic goals and citizen duties. It really changes the game for what rights mean on the ground.
It absolutely does. It reflects a maturing understanding that rights aren't just isolated legal guarantees. They're interconnected, they depend on socioeconomic conditions, and they flourish best when both the state and citizens play their part. It's a system striving for a more complete vision of human dignity.
So wrapping this up, what does this all mean for you, our listeners? Today, we've really taken a deep dive into India's quite complex, multi-layered system for protecting human rights. We started by looking at who violates rights and who's most vulnerable. Then we explored the big players, the NHRC, the state-level SHRCs, and those really important specialized commissions focusing on specific groups.
And we've also seen, crucially, that this landscape is anything but static. The judiciary is playing an incredibly active role, not just enforcing rights, but actually expanding the definition of fundamental rights, recognizing vital protections like privacy, a clean environment, and doing it through innovative methods, like linking those directive principles and fundamental duties back to core rights to make them more effective. It really is a system that's constantly trying to adapt and improve.
Yeah, it's clearly a dynamic and living system. It's designed to uphold the rights of all citizens, even if that journey towards, full and perfect protection is always going to be ongoing.
Absolutely. And maybe as you reflect on this intricate system, here's a provocative thought to leave you with. In our world, where technology like AI, climate change, global migration, all these things are constantly throwing up new ethical dilemmas, how might the very concept of human rights continue to evolve globally? And what new responsibilities, what new duties might that place on both states and maybe even us as individuals in the future?
Something to definitely keep thinking about. Thank you for joining us on this deep dive.